On Friday, Matthew Hoover and Christopher Irvin were convicted of a series of firearm-related crimes in the United States District Court in Jacksonville, Florida. I've been asked to make a bunch of observations about this case, which I will now do. There's a lot to be said about this case. Let's talk about it. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the right to keep and bear arms and the four boxes of American liberty. Okay, folks, I'm going to talk about the Matthew Hoover case because there's been an overwhelming number of people, both on Twitter, which you can follow me on at Four Boxes Diner, and on YouTube, asking me to comment about this case. It's not a case I followed extensively, but I spent last night several hours reading about 700 or 800 pages of documents that I could pull off the court document. I should disclose right up front that I do not have access to the trial transcript, so I'm flying a little bit blind here as to what actually happened at trial because I don't have the transcript, so just keep that in mind. And number two, I want to give NRA instructor John Crump great credit for an article he did in Ammoland, which summarized the first week of the trial, and I'll put a post to it down below because I did read his article. I thought it was very good, so I'm relying a lot on his reporting at Ammoland, which again I thought was a great reporting, so I also am using that to try to get me up to speed on some of the details of this case. I know a lot of other YouTube channels have covered this, but there's a lot to be said about this case, and I'm going to try to give you information that you may not hear anywhere else. To begin with, Matthew Hoover and Mr. Irvin were convicted of a series of counts on Friday. Now, in no particular order, number one, Mr. Hoover, Matt Hoover, did not want this case to be tried in Jacksonville, and he did not want this case to be tried with Mr. Irvin. The reason why this is significant is it's pretty clear, having reviewed the filings I reviewed from the United States government in this case, that they desperately wanted to make sure they could put Mr. Irvin and Mr. Hoover together in the same docket, if you will, in the same case, because Mr. Hoover said his case should be tried separately from Mr. Irvin, and that was denied. And the reason why that was denied is the U.S. government wanted, of course, to try them together, which meant that any alleged bad activity by Mr. Hoover could be applied to Mr. Irvin and vice versa, even though you may tell the jury that's not the case. That is what they did. And the way the government was able to, I think, pull this off is they threw in a conspiracy charge that says that Mr. Hoover and Mr. Irvin were conspiring together to sell, of course, these alleged machine guns, which under the federal statute, parts of machine guns equal machine guns. We'll get to that in a second. And because they argued it was a conspiracy, the government argued to the court that they needed to try the two defendants together, and the court agreed because it's a conspiracy case. Now, just as an observation, this has to be one of the world's dumbest conspiracies, if this is a real conspiracy, if you think about it, because they literally advertise this on YouTube. It's not exactly like a secret backdoor or backroom deal trying to, hide around and do some major crime or anything like this, right? They literally did whatever they did, whatever you want to characterize this as, out in the open. So that's the first observation. The second observation is this case is not over. What I mean by that, and this is important, there is no such thing as summary judgment in criminal cases. This was a criminal case, not a civil case. The reason why this is important is summary judgment is a mechanism whereby a court can decide a case before there's a trial to avoid the need for a trial in a civil case. The process of summary judgment, however, is not available in the context of a criminal case, which the Hoover case, United States versus Hoover, was a criminal case. And why is this important? It's because the way you handle a criminal case like this, a trial, is the defendants, which they both have done, they file motions to dismiss the indictment, they file motions to be found not guilty in light of the trial evidence not being enough for a reasonable juror to conclude that they're guilty, and so on and so on. So those motions are pending. I'm sure there will probably be further motions for an acquittal by both defendants coming. And because, again, there's no summary judgment tool, these decisions usually get made by a court after there is a jury verdict. So we will see what this court does with those motions about whether or not they can be acquitted and found not guilty. But again, Unlike a civil case where a lot of that happens before trial, in a criminal context, usually those motions get resolved after a trial because the reason from a point of view of the judge can avoid a lot of work if the case is tried and the defendants are found not guilty. Then the judges don't have to spend the time to write the opinions on the issue because it becomes moot because the defendants get to go free. So oftentimes, most times, the judges will wait until after the trial to make these decisions on motions for acquittal, notwithstanding any evidence presented at trial and the like. Okay, so we'll see what the judge does there. And of course, there's obviously the option for an appeal. Now, the third observation I want to make, and I'm not going in any particular order here, is this is important to know for the future. The government was running scared in this case. And you're like, how do, and I can tell that just from the limited documents I looked at in the court docket. And I certainly did not have access to all of them, including the trial transcript, which would be the most valuable stuff to look at. The reason why I say they were running scared is because on April 18th, which was in the middle of the trial, I believe, the United States submitted a supplemental proposed jury instruction. This is all I needed to know that the government was terrified about losing the case. Why? Because if you look at this filing, which I'll put a link to down below, the government begged the court, asked the court for specific jury instruction that says the following, quote, the government does not have to prove, this is the instruction they asked the court to give. It wasn't given, by the way, but this is what they wanted them to give. Quote, the government does not have to prove that the item described, which is the auto key card, the government does not have to prove that the auto key card item described in the indictment would have here's the key, would have successfully converted a particular individual's weapon into a machine gun, or that the defendant or another individual possessed a fully assembled machine gun. It is only necessary that it prove that the defendant designed and intended, hear what I just said? Designed and intended the item, which is the auto key card, to convert a weapon to shoot automatically more than one shot without manual reloading by the single function of a trigger. That was what they asked. Why did the government ask for this? It's pretty clear the only reason why the government would ask for this instruction at a trial that, as I can tell, is that the government realized that in the totality of the evidence presented against Mr. Hoover and Mr. Irvin, they were not able to establish that the alleged parts in the auto key card actually could be used to convert a semi-automatic AR-15 into a fully automatic machine gun, which really is a critical part of the elements of the crime. Because if you think about it, if I go to McDonald's and I take a coffee cup and I cut it up into like 4 little squares, and in my brain, maybe I'm not that smart, in my brain I'm thinking, oh, well, you know, these four little things, this will allow me to turn my AR-15 into a machine gun. Obviously that's stupid. That's not possible. So even though I intend, in my hypothetical, to convert the McDonald's coffee cup parts into a conversion kit to take my AR-15 into a machine gun, that's obviously absurd. And the reason why it's absurd is it would be impossible for those parts to be used to convert a semi-automatic AR into a fully automatic machine gun. So here, the government, with the submission, as I see it, is essentially admitting, or coming awfully close to admitting, if not fully. This goes back to why the trial transcript would tell me more. But as I read this, they're basically saying that, hey, we, the government, are nervous that we have either failed or we cannot show that the auto key card and or the alleged parts in the auto key card, that's another subject of debate, if cut out with some fancy-dancy tool with all this other stuff, it won't actually convert a semi-automatic weapon into a fully automatic one. Well, if it doesn't convert it, how is that any different than Mark going to cut up a coffee cup, at a store somewhere and saying, I intend this to convert a gun into a machine gun? That's absurd. And the government must have felt that they had failed in this critical thing, and they wanted to get around this with this jury instruction. I think that's quite telling, and this may actually be some sort of an interesting angle on appeal when we see the trial transcript. But beyond that, I want to point out this is also quite interesting because it subverts a public press statement that the Department of Justice issued after trial. Now, if you think about it, in this jury instruction they're proposing on April 18th to the court, where they're essentially saying that we don't have to prove that this auto key card could successfully convert a particular weapon into a machine gun. Well, if they can't show that these items, whatever these items, these auto key cards or any aspect of the auto key card could be used to convert a semi-automatic weapon into an automatic weapon, well, here's the question. Where's the public safety or public interest in messing around with this case? Because if you look at the public press release that the Department of Justice issued, here's what they say. They say that this case against Mr. Hoover and the like, right, quote, this case is part of a Project Safe Neighborhoods, a program bringing together all levels of law enforcement and communities they serve to reduce violent crime and gun violence, and to make our neighborhoods safer for everyone. Okay, here's my question. If the government is essentially admitting with their supplemental jury instruction request that they don't have to prove that these auto key cards actually worked, well, then how the heck on earth does this make any difference in public safety in any respect? And how does this impact, according to their press release, violent crime strategy, reduce violent crime, gun violence, if this piece of metal does no good or doesn't work? Interesting, right? So the next observation I want to make here, and I'm going quickly in no particular order, is I think this case does raise some major First Amendment issues. And I wonder whether or not the jury charges ultimately are a problem for the government. And I say this because we know that you can go onto Amazon or any basically bookseller right now, today, and buy a copy of the Anarchist Cookbook, which basically describes all sorts of bad things that you could do, many of which I presume are illegal. And yet that you can buy on Amazon. I checked this morning, you can buy a copy of that book on Amazon. So what's perplexing to me is we know that under the First Amendment right of free speech, that books such as the Anarchist Cookbook are indeed protected by the First Amendment. And there's other things that are protected by the First Amendment. And we know that booksellers that sell these books are also protected by the First Amendment. And the fact that a bookseller is selling such a book that has diagrams, images, pictures, written words, and the like, descriptions of how to engage in bad stuff, that's not viewed as a conspiracy. Even though the bookseller's making money off the sale of the book, presumably, and the author of the book is making money off the sale of the book, presumably. So how exactly is that any different than here, where you have Mr. Irwin, or at least Mr. Hoover, engaged in selling this device, which at the end of the day seems to me a piece of metal with information on it, right? It's essentially containing information. I don't quite know how that's different than a thumb drive, a book, piece of art, painting on it. I don't know. I don't quite understand how this is dramatically different than a book. The reason why this implicates the First Amendment concerns is that the government seems to basically have been saying, well, no, the First Amendment doesn't really apply here. But the way I might have done this, and the way I think the jury instruction could have been framed differently, again, I read what I think is the final jury instructions. They may not be. So again, you got to take everything I'm saying with a grain of salt here, because I don't have all the information in front of me, and I could be wrong on some of this when all the information comes to light. So just keep that in mind. With that said, it seems to me that one of the things that should have been charged to the jury is something along the lines of the following. And I think I might have put that First Amendment defense somewhere in the context of jury instruction number 9. Jury instruction number 9 says that references to firearms and machine gun devices here, you have to follow them. And remember, the jury is to determine whether the auto key card is a machine gun subject to firearm laws and regulations. And remember, this is really a question of fact for the jury. But this is where I might have added something along the lines of the following if I were the judge. I might have said, nevertheless, if you, the jury, find that this auto key card is more akin to a piece of art, graphic design, or to a book, or some other parchment or material that contains information on it, then you could consider whether or not that speaks to the intent of the defendants as to whether or not they fully intended to use this to convert something into a machine gun or not. I might have specifically flagged that concern that if you think, ladies and gentlemen of the jury, this is nothing more than conveying information to the consuming public on par with, again, a book, well, that is something you can consider in the factors whether or not you think the defendants intended to do what they did here. And yet there is no reference along those lines in jury instruction number 9. I think that may have been what I would have done if I were the judge. But again, I wasn't the judge there. And it looks like mostly what they did is they followed some of the pattern jury instructions down there in the 11th Circuit and modified it slightly. But again, I don't know the back and forth of all this between the lawyers and the court, but that's might be something I would have done as a judge to protect my record so I don't get reversed on appeal and have to potentially redo the case down the road. Now, the next thing I think that's important is apparently it appears as if the witnesses, some of the witnesses testifying for the government were doing so under immunity deals, which means the way this works is, in reality, the government can go to someone and say, look, we think we've got you over the barrel. We think we can put you in prison, maybe because we're going to claim and we're going to indict you and claim that you possessed an auto key card, and we're going to say it's a machine gun, and we're going to say you possessed an unregistered machine gun, and you're going to go through living hell for the next 2 years, and you might be found guilty and go to prison. Or maybe you can come on down to Jacksonville for a few days and we can prep you and we can get you on the stand and have you testify in a case in this Hoover case. Now, the reason why I suspect this happened is jury instruction number 7. Again, I'm inferring some of this stuff here because I don't know for a fact, but jury instruction number 7 tells me this was the case. Why do I say that? Tell me what you think. This gives it away. Quote, a witness who has been promised immunity from prosecution or a witness who hopes to gain more favorable treatment in his own case may have a reason to make a false statement in order to strike a good bargain with the government. Now, this is something in the context of a jury considering the credibility of witnesses. Now, the only reason, as I see it, that you would put this kind of language in a jury instruction that you would give to the jury, this is jury instruction number 7, at least according to the court docket I was able to pull up, okay? Why would you give an instruction that you can discount the testimony of a witness who's been promised immunity if you don't have witnesses that were promised immunity in the case? If it's not a factor, you wouldn't need to give this charge, which tells me that some of the witnesses that came to testify, presumably the people that bought these auto key cards, had that kind of a conversation with the government, and they showed up to testify on behalf of the government. So again, nothing illegal about that, but it certainly speaks to the credibility and seriousness of some of the testimony of these witnesses. I should also note one other thing I might have been interesting if this came up at trial is, are there any other prosecutions in America for this auto key card? In other words, has anybody in possession of an auto key card been prosecuted? That might have been kind of interesting, something to get one of those ATF witnesses on cross to say, like, how many other people have you indicted in America to date for possessing an auto key card? And if the answer is none, I'd be like, ha ha ha, ladies and gentlemen of the jury, that just goes to show you this is a BS case. Because if these people were truly careful, right, if these people lived up to their reputation on their website, then I would have quoted, this great language, grandiose language about protecting the public on the ATF website or DOJ website. If they really wanted to live up to all of this, ladies and gentlemen of the jury, don't you think they would have prosecuted all these thousands of people that allegedly got auto key cards across America, and yet they haven't indicted anyone for possessing machine gun? So why not? Why haven't they done that? Maybe because the ATF doesn't really believe this auto key card makes up the parts that constitute a machine gun under the statute. That might be how I might have played the game. That may be exactly what happened. Again, I don't have the trial transcript, but that might be how I would have played this up if they hadn't prosecuted anybody else in America other than Mr. Hoover. Then, of course, I might have actually played up with respect to Mr. Hoover that, here's a guy that is known as a Gadfly to the ATF, and that's why they went after him. Now, it's not technically a selective prosecution argument. I don't think that as a matter of law would work here, but I do think it's the sort of thing you could point out to a jury to say what's really going on here is they don't like Mr. Hoover's views, and I might have, if I was a defense counsel, again, this may have happened, I don't know, I might have played a series of videos where he's criticizing the ATF and say, look, he criticized the ATF and they all know this. And that's why the ATF is coming over here. So they want you to focus on this auto key card, but the reality is they're motivated to gin up this case because of Mr. Hoover's political views. And then I would have played a series of videos, if they existed, by the way, of Mr. Hoover criticizing the ATF and the Department of Justice. And I would have tried to use that to raise questions about the motive and sincerity of the case to the jury. Again, this may all have happened, but that might be how I would have done it. Again, it's all very contextual. I'm not second guessing anybody. I'm not in that kind of a position. I'm just throwing it out there for some, again, consideration. The next interesting point here is that the government wanted to call as a witness, at one point at least, Mr. Hoover's wife. Now, you usually cannot call spouses to testify against another spouse because that falls into what's called the marital privilege. However, the government says, well, we only want to ask Ms. Hoover questions about things that occurred before the marriage. Now, that I thought was kind of interesting. Like, what the heck are they talking about here? And I don't know whether or not Ms. Hoover, Matthew Hoover's wife, was called to testify. But if she was, I'd be very curious to see why the government would call her as a witness. And what would the point of that be? Just seemed kind of odd to me that there was a fight about that before trial. But again, I don't know if that came to pass or not. I guess we will see. The next thing is, a lot of people have raised questions about what is the structuring charge, this financial transaction structuring charge against Mr. Irvin. And what was that about? Okay. I think to me as a trial lawyer who's done much bigger cases than this one, I have a feeling I know what this was about. Now, structuring in 30 seconds is this, that there's certain rules under federal regulations that banks have to make certain reporting requirements under their law for transactions involving more than $10,000. I won't bore you with the details. The allegations here was that Mr. Irvin, with his local bank that he used to bank, somehow I think the argument is that he withdrew more than $10,000 over a period of a few days from different branches of this one bank, and that was somehow structuring. So what? I don't quite understand the charge here, but I think I know why they did it. Here is why I think the Department of Justice and the U.S. Attorney's Office charged structuring against Mr. Irvin, even though it seems kind of like, what does this have to do with public safety? What is this? It just seems like it didn't seem to smell like a crime to me. But I think the reason why they charged it is the government wanted to call to the stand bank employees because, as I understand it from the reporting of Ammoland and others, this came to light when a bank teller or bank tellers had a series of fights, not physical fights, but arguments and fights over how to engage in certain transactions with Mr. Irvin and his bank. There was a debate about, hey, how to handle certain, no big deal. It sounded like no big deal, but there was a fight. And at some point, someone in the bank Googled his business, and in the context of Googling the business, found a website for this auto key card and called the ATF. At least that's my understanding of what happened. So what I think may have happened here is to make sure that the bank employees and the bank officers or whatnot could definitely testify as being relevant, because if they weren't relevant witnesses, the government could not call the bank employees to the stand. So I think what the government may have been thinking is, we have to make sure, we think it's good for our case to call the bank employees to the stand to talk about what a jerk Mr. Irvin was in the context of this. And the only way to make sure they're relevant witnesses is we have to have a criminal charge that makes them relevant. And why don't we add a structuring charge so we can definitely say to the court, we need to bring in these bank witnesses for the structuring charge. But the reality is, even though, yes, they're relevant to that, you can also kind of taint Mr. Irvin's reputation and make him look bad for the jury in terms of the other counts, but you had to make sure the witnesses testified. I think that may be what the government was thinking here, but at the end of the day, I don't know exactly. That would be my speculation as to what they were thinking. The next point I want to make is about jury instruction number 14, which speaks to intent. Specifically, it says, a defendant can be found guilty of his crime only if all the following facts are proved beyond a reasonable doubt. Then the court goes on to say that the defendant knowingly transferred or aided and abetted the transfer of a firearm, specifically and this is key, a combination of parts designed and intended for use in converting a weapon to shoot automatically more than one shot, and so on and so on. Here's the key words: a combination of parts designed and intended. So obviously, I'm sure the defendants argued that the auto key card was not a combination of parts, that the auto key card was at most one part, right? Because it's a card, a singular card, a card, which is a part. And the statute requires a combination of parts. You can't have a combination of a single part. You don't have a combination of a part. You have to have multiple parts. So presumably they argued to the jury that there had to be multiple parts here and the auto key card was a single part. Beyond that, I presume they also put on evidence that said that when you cut out these parts, they would cause the parts to roll up. Because remember, this is not woodworking. These are metal. My understanding that when you cut metal is that the metal always wants to roll up on you, which makes any alleged parts not work unless you're using a very fine, highly expensive laser cutter for metal, which is highly unlikely anyone would be using that. So that's the first observation about this jury instruction number 14. The other thing is the word whose intent counts, because it says a combination of parts designed and intended for use in converting a weapon into a machine gun. But here's what's interesting. The government tried to show that the parts designed and intended, and they wanted to prove this by bringing on witnesses. Presumably, this is my guess, some of the witnesses that potentially had immunity deals, maybe because they called in customers, and in my understanding, at least from the reporting that I've been able to see, is none of the customers seem to have converted any of this or done anything with these auto key cards. Some of them may have even thrown them out. Nevertheless, why would the intent and understanding of the customers be relevant to the intent and understanding of the defendants themselves? You see, so this jury instruction number 14 might be a way to wiggle around some reversible error here, because it just says a combination of parts designed and intended for use, but whose intent counts? So this goes back to, if I intend to sell a VCR as a VCR manufacturer, or a Betamax VCR, or a compact disc company. I know I'm using older technology, but it's because it makes the point clearer. If I want to use a Betamax or a VCR, or I want to use a CD player, and I want people to be able to watch lawful movies, let's say, or home movies that are lawful, that's my intent. You see what I'm saying? That's my intent. Now, if it turns out that some third party buys my recording device, and they use that recording device for an illegal purpose, like illegal pornography, let's say, you see, you can't call that witness to the stand and say, this customer of Mark's bought this recording device from Mark and then used that device to engage in illegal conduct, such as watching illegal pornography. And therefore, Mark is to blame because the intent of use by this customer of Mark's can be imputed to what the product that Mark designed and intended, when that's not the case. So I think there may be some ability to fuzz around with jury instruction number 14 on appeal and be like, look, it wasn't clear. It's all about the intent of the defendants. They're the ones on trial. So why is it the intent of a customer relevant to the intent of the defendants? I know there's arguments both ways on this, but that would be certainly something I would want to flag. Now, on the Second Amendment, the reason why I don't think we have a good Second Amendment argument here right now is because the Supreme Court, rightly or wrongly, in Heller, and it's still the good law, basically says that M16s, which are really machine guns, right now are not protected by the Second Amendment. They're not viewed as protected arms. That is the law of the land today. I'm not saying that's going to be the law of the land forever, but for the purposes of right now, which is all that matters for Mr. Irvin and Mr. Hoover, right now, the Second Amendment authority on that one specific point is not very strong, I would say. It's an argument, but it's not very good in light of the dicta in the Heller case. The last two interesting things I think it'd be interesting to find out what happened is, I noticed on the exhibit list, which runs 42 pages by the government, exhibit 17-1, I won't bore you with the details, but it's in the 17s here. They apparently had recorded a series of jail phone calls between Mr. Hoover and Mr. Irvin, which seems perplexing because I don't quite know why the criminal defendants would be communicating directly. Usually if there has to be some level of communication between the two sets of defendants, the lawyers can talk and coordinate a defense. So I don't quite understand what these phone calls were, these jail phone calls between Irvin and Hoover that were on the exhibit list, whether or not that came into trial or not. I'd be curious to see if they did come in, how were they used by the government, and what were they all about. Okay, so there's a lot more that we can say about the Hoover case at some point. If I get a copy of the transcript, I'll try to read through it and give you some other observations. But based on my limited review of what I saw, these are my initial impressions. At the end of the day, I think that it seems a little strange that this was the kind of case that the ATF would spend a lot of time and money on, but I guess why not? It's high profile. We're all talking about it. And I think a big part of when the prosecutors go after a particular person or case, they like high profile people because it teaches everyone else to get in line and to behave. And there's some merit to that argument. You want to set examples for the rule of law, and presumably now people understand there's certain things you can and cannot do or you have to be worried about. And if you're going to do something like do an auto key card, there's a strong argument that rather than go out and just do it, you may want to run it by the ATF. I know everyone hates that notion, but it's better than going to prison, right? And again, I don't know what's going to happen in this case. There will certainly be a ruling on the motion for an acquittal, notwithstanding the jury verdict. There will also be appeals and other battles, and it will go on and on and on. But the reality is both Mr. Irvin and Mr. Hoover, as of now, have been convicted of pretty serious federal crimes with hefty criminal penalties, including jail time. Only time will tell what happens. I think the date for the final sentencing is sometime over the summer. And again, if you guys are interested in this, I'll be happy to kind of keep you apprised, although I know a lot of other channels cover this topic, and that's why I haven't done a lot of it, because I figure you guys are getting this information from other places. But if you really want me to cover this in detail and geeky detail, I'm happy to do a little bit more of it. Okay, folks, hope you learned a little bit something today. We'll keep you apprised of all that's going on out there. And if you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.